Now we have Raul Quintero and Steve Branning. So we're expecting great things.
I hope to meet your expectations, Your Honor.
You always have.
Thank you. And just for the record, in case the panel, in case it's not obvious to the panel, for the record, I do remember how to shepherdize.
Unfortunately, I think we all do.
Yes. I was trying to explain that to my son who's in law school, and he was incredulous.
Yeah, I know. Okay, you're up, Mr. Quintero.
Your Honor, may it please the court, I represent the appellant DeSoto Waste Services, and this is on appeal from a judgment for roughly $6.3 million on a bench trial for breach of contract of a waste hauling contract. What I'd like to do with the panel's indulgence, I just want to dive right in to issue number 1C, and that's because I submit that it's dispositive and the appellee has not really responded to that particular argument. And that argument is that they failed to prove their damages because they saved a lot of costs from the transportation that were not included in their damage analysis. The evidence, the testimony was undisputed. Mr. Lomangino, the Southwest CEO, admitted that transportation is one of the things that you consider in pricing. That's on page 134 to 35 of the trial. And all the outside counsel did, the damage summary was provided by Southwest outside counsel. It wasn't an expert. It was just a lawyer, the corporate lawyer, who developed a chart of this is the haul that we did with DeSoto and the prices, and this is the haul that we are doing with Southwest land disposal at SLD. And here's the difference in the price, and those are our damages. And she got to somewhere around 6.7, and the judge in the judgment reduced it to about 6.3 million, including the pre-judgment interest. So she admitted that's all she did. We presented testimony that was unrebutted, and everybody agreed that you save on transportation costs when you go, instead of going from Fort Myers, where Southwest is, to east of Arcadia, where DeSoto is, and instead you are hauling from Fort Myers to Punta Gorda, which is essentially half the distance. You're going to save a lot of transportation costs. And these aren't Priuses that are hauling waste here. These are 20-ton, 18-ton, some kind of ton trucks hauling a lot of waste. In fact, the prices were per ton of waste that is deposited. So obviously it's a lot of weight and it's a lot of costs that are saved. We cited in our brief the same restatement of contract provision that Southwest cited in their trial brief on page record 1213. And we note that in our brief, everybody seems to agree that restatement section 347 applies. Well, that provision, paragraph C, provides that any cost or other loss avoided by not having to perform should be deducted from the damages. So that's something that they needed to have deducted. They didn't deduct, they admit they didn't, and therefore they failed to prove their damages. So our first argument is that for that reason, judgment should be entered in our favor, but at least there needs to be a new trial where all that evidence is presented.
I understand your argument, I think, but you're framing it in terms of they failed to prove damages as opposed to their proof of damages they proved damages, but it was, an element of it was flawed. I'm trying to understand how translate the fact that they didn't take into account the difference in transportation costs, how that equates to they didn't prove damages as opposed to their proof was flawed.
Your Honor, it may be a matter of semantics either way. They did not prove an element of their claim, which is, in a breach of contract claim, one of the elements is damages. And if you fail to completely prove damages, if it's incomplete, then you haven't proved your damages. And so it was incomplete because it didn't take this into consideration. And it's not like it's a small cost here. We all know through logic, when you have transportation costs of 20-ton trucks that are going half the distance, instead of 55 miles, they have to go 28 miles. That's a substantial reduction in costs.
Did their witness explain why that wasn't taken into account in the calculation, even though the witness acknowledged that it was a relevant factor?
Let me be clear, Your Honor, and I apologize if I mistook. Those were two separate witnesses. Okay, the witness who testified that transportation has to be taken into account in pricing was the CEO of Southwest.
Mm-hmm.
The witness who testified that she didn't take that into account was the outside general counsel of Southwest, who developed the damages summary.
And was she questioned about why she didn't do that?
I don't recall that she was. She just said, no, I didn't. All I did was this. So you didn't do anything else except compare their price or the DeSoto price to the SLD price and add them up. And then you did the consumer price index and you added it all up. Yes. And she went, the other thing she did that we have appealed is, even though the SLD contract was a 5-year contract, she went and extrapolated it out through the life of the DeSoto contract that remained at the end of the period. So it remained from late April through August of 2028, and she extrapolated it out past the 5-year period of the SLD contract, which you're also claiming is wrong. But you don't really even get to that if
let me ask a question on that transportation cost, Mr. Quintero. Were the trucks going to the landfill from the same place every trip?
Well, the calculations that she made were trying to compare
calculations you
apples to
said
apples.
omitted the transportation cost, but what I'm asking is that and this is, I don't know, this might be inaccurate, but in my head, the trucks are picking up waste wherever the waste is and then hauling it to the landfill. Is that correct?
There's some of that, but a lot of it is taking it from the transfer station, because Southwest had a transfer station in Fort Myers, and that's where they were taking it from.
Every trip.
I'm not going to say every trip, Your Honor, because it's really not in the record.
And so it's not in the record one way or the other, and what the percentages of those are. I know they had a transfer station, but you acknowledge that they weren't always driving from the transfer station.
Well, we don't know that either. We don't know that they weren't always. We just don't know it was 100% or not 100%. If there are no other questions on that issue, and again, I think that's dispositive. They just didn't introduce that evidence. I'll work my way backward then to whether there was a breach. Yes, on March 17th.
Before you get into that, just for my benefit, please, would you incorporate into your argument the timeline? Because between reading your brief and Mr. Brannick's brief, I'm not clear exactly in the trial court's findings. I'm very confused about the timeline in the case.
Yes, Your Honor, and that's really part of argument number one, A and B, is the timeline. So on March 17, DeSoto said, hey, we are terminating this contract. March 17 of 2021. We're terminating this contract. you are the purchaser of the contract, the assignee from somewhere else. We didn't approve that. We're going to rescind it. They met the following day, March 18th, they met. There was no agreement there, but they kept negotiating after that day. On April 9, DeSoto sent a proposed new contract that would increase the price from $7.75 per ton to $9.25 per ton. But it was only valid till the end of the year. And the testimony from Southwest was, we wanted something more long-term. And just to put it in context, Your Honor, the SLD contract started at like 18 something per ton, so twice as much, which is also, by the way, circumstantial evidence that they didn't mind having a closer facility, even though they had to pay double the price, because they're going to save on transportation costs. It just stands to reason. But to continue with the timeline, Southwest did not accept it. They claim that the unexecuted contract is evidence that there was no contract left over. But it's actually evidence that there was a contract, because the unexecuted contract says this terminates the prior contract. But of course, it doesn't terminate it until it's executed, and it wasn't executed. That's on April 9. On April 21, unbeknownst to DeSoto, Southwest executes the contract with SLD. On April 22, DeSoto sends a termination letter to Southwest. On April 26, Southwest responds and says, wait a minute, this is still valid. We're surprised that you are saying that you're terminating. We've been operating under this contract. And so one of our positions is this is further evidence that this contract was continuing. In fact, between the time of March 17, the original date that we're going to terminate this contract, and April 29, when they finally no longer accepted any delivery. So that's the end of the factual timeline, March 17 to April 29. The undisputed evidence was that there were 450 loads taken to the DeSoto facility, accepted by the DeSoto facility, invoiced by the DeSoto facility, and paid by Southwest. So it couldn't have been that they terminated the contract on March 17, when in fact they continued to operate under the contract. And yes, DeSoto's intent was eventually we're going to get a new contract. But in the meantime, they were operating under the old contract and accepting loads, 450 of them in 6 weeks, and invoicing and getting paid for those loads. So back to the April 22 termination letter. The reason for that letter was we cited unacceptable waste that was submitted in the loads.
Let's come back to your point that you just made, the first, so during that time, after the phone call, but before, would Southwest had any expectation that your client was going to continue to accept loads at that price for the remainder of the original contract when this was happening? Would they realistically have had that expectation, or based on the conversation, did they know this was not going to happen?
Well, the conversations were ongoing. In fact, as late as April 9 is when we sent the new contract. So from March 17.
So the negotiations for the new contract were ongoing.
Yes.
So they would have known that the old contract was no longer in effect.
Well, not that it was no longer in effect.
Or was not going to be honored.
They suspected that eventually it would be terminated, but it wouldn't be terminated until there was a new contract, at least as of April 9, because that April 9 contract says that it terminates the prior contract. So obviously it contemplates that there was a contract being terminated as of the time of whenever that contract was executed.
Okay, Mr. Cantero, you did not, if I recall correctly, mention whether you wanted to do about rebuttal time, but you're coming down to your last 5 minutes.
You're absolutely right. After all this, I'm still a rookie, so I do reserve 5 minutes for rebuttal. And thank you for your time.
I won't take any points off. And Mr. Brannick, you're up.
Good morning, Your Honor. Steve Brannick, representing Southwest Waste. This final judgment is based on fact finding by the trial court, all of which was based on competent substantial evidence. And so this court should affirm. It's as simple as that. First is the issue of when was the breach and who breached. The evidence is clear that Southwest, that DeSoto improperly and unequivocally terminated the contract on March 17th. Mr. Gabbert, the owner of DeSoto, told Mr. Lamangino, the owner of Southwest, that the contract was terminated, that it would not stand. He reiterated this statement the next day. It was never retracted. And then when they sent over this new contract that was being negotiated, the new contract says that the old contract, quote, has been terminated, close quote. Now, they make much of this so-called continued performance, but as the trial court ruled, this continued performance was just an accommodation by DeSoto while they negotiated the new contract. It's clear that the performance was not under the old contract. It was completely at DeSoto's sufferance. Essentially, it was at will at that point in time. There is a huge difference between having a 10-year contract where you know that you can deposit your waste tomorrow, next week, the month after that, the year after that. There's a big difference between that and a contract where we don't know when we show up whether they're going to take the waste or not. The whole point of that contract was to have that 10-year certainty, and that 10-year certainty was gone. The contract was gone. And even if this, and at the end of the day, this argument about whether the breach was on March 17th or on April 28th, when they unequivocally stopped taking Southwest waste, it's really, that's all much ado about nothing, because the only reason they're making that argument is so that they can suggest that the real reason that they terminated was because of this unacceptable waste. But they have a huge factual problem on that score, because the trial judge said that the unacceptable waste was not the reason for the termination. This was just an attempt to shake down Southwest to get out of an unfavorable long-term contract. When they first raised the issue of termination, the only issue they raised was the fact that they argued that the contract that Southwest Waste had assumed was not assignable. They never said a thing about unacceptable waste. They didn't start to complain until Southwest rejected this shakedown attempt and got a contract elsewhere. The trial judge ruled specifically that the unacceptable waste they were talking about was not a material breach. That's a factual question. Out of thousands of deliveries, the evidence was there was only 11 reports of unacceptable waste. Just to give you a couple examples, one load had 23 tons, and there were a couple plastic bottles in the soup can in it. Another 29-ton load has some food waste and an empty bottle of oil. Their own witnesses said that these minor problems happen all the time with all their customers. No other customer had ever been terminated for that sort of minor problem. And frankly, they'd be setting an impossible standard. When you have these dumpsters out there, there is no way you can guarantee that the waste is going to be absolutely pristine. The judge said, I could say this beyond a reasonable doubt. There was no material breach here. And this, again, was just an attempt at a shakedown. So you go to the damages question. It's a very straightforward calculation. It's the difference between the two contract prices. The trial judge said that the calculations were appropriate and reasonable and that they considered all necessary items, and it just put us back in the position.
Well, but I think the appellant's argument is that they didn't consider everything because they didn't take into account the reduced transportation costs, which their own witness said was relevant.
There were two big problems with that argument. The first big problem is that they didn't raise this issue about transportation cost savings until the afternoon of the last day of the trial. It had never been an issue in the case before that. The trial judge said that that was trial by ambush. It was highly.
Well, I think that wasn't that in the context of whether or not to let their witness testify about what the reduced cost would actually be, as opposed to what I think I'm understanding the argument that Mr. Cantero made is that your proof was lacking because your proof did not include that element.
We didn't include that element because there weren't any cost savings. And I think the point that the judge was making about this trial by ambush was that if they had come to court with competent evidence that there were in fact cost savings as a result of the change in the waste depository, we would have been able to rebut that. We would have been prepared with all sorts of evidence that would have shown that there was no cost savings. I mean, at the beginning of this contract, there was one location from which waste was being hauled. By the time this contract was being performed, the waste was coming from a number of locations. And so to say that there perhaps were some cost savings that from waste from one location doesn't address any of the other locations. And again, that would have all been evidence that we would have been prepared to present had we known before the end of the last day of the trial that this was going to be an issue. I mean, there are all sorts of other.
But okay, but your witness testified that that was an appropriate element, but yet didn't take it into account. Is it? And I mean, if it's your burden to establish the amount of damages, and your witness doesn't include an element in that calculation, why is that not on you as opposed to the appellant?
We did. The element that their problem is that the element was zero. We have the difference between the two contract prices, and there was no evidence of any cost savings. Now, they certainly would have had the right, had it been properly disclosed, to come into court and say, wait a second, we've got evidence here of cost savings. But the problem is they didn't show up with any evidence. They showed up with an incompetent witness who was going to talk about what he thought Southwest Waste cost structure was going to be and transportation cost structure was going to be. This witness had was not competent to talk about things like that. He wanted to talk about transportation costs in the industry. And if you do that, you're basically an expert witness. So the bottom line is they didn't come to court with any evidence that there was a cost savings as a result of the breach of the contract. And again, had that issue been raised, had they come to court with that evidence, we would have been prepared to rebut it. In our view, that number was zero, and they have no evidence to the contrary. To say that loads from this one, that it might be a factor that loads coming from this one place are going to have a shorter trip, that's just one small factor. But what about the loads coming from other locations? Or what about the fact that we're now at a different landfill facility that might have different procedures for dumping waste and different requirements? And of course, all of that could have been addressed. And if it had been addressed, it would have shown that number was zero. So the problem was this was an issue that was raised at the last minute, and they had no evidence. So the trial judge heard all that. He was intimately familiar with the facts supporting the damages. They didn't make any other challenges to the math of the documents that we presented. So the trial judge's findings were based on competent substantial evidence. So we think that we in fact proved breach and we proved our damages. And for those reasons, we think that this court should refer.
Thank you, Mr. Brannick. Okay, Mr. Cantero, you're up for a 5-minute rebuttal.
Thank you, Your Honor. To address Judge Kelly's question, neither in their brief nor today have they argued that the burden of proof on this is on us. What they have said in their brief is they didn't have to do that. And in fact, if you look at pages 25 to 26, bottom of 25 to top of 26 of their brief, they say DeSoto ignored that the cost of transportation is simply one of many variables that may impact the cost of a load, such as the equipment used to transport the load, the nature and efficiency of this disposal facility. And so they're actually admitting there that they didn't take any of this into account, that they made a very simplistic damage summary by their outside counsel, simply comparing our contract to the new contract and the prices. And what their brief shows and what their witness agreed to was it's a lot more than that. Their witness agreed that transportation is something that you have to account for in the pricing, and it stands to reason. And to Judge Northcutt's point, well, maybe a lot of the loads weren't coming from Fort Myers, the DeSoto facility, but they may have been even closer to SLD than to Arcadia. And so it saves them even more money if they're going from close to Punta Gorda to SLD than if they have to travel to Arcadia. So it's really not relevant, even if they don't come from Fort Myers, from the actual facility, because they can still be closer to SLD than to DeSoto.
So Mr.
they-
Quintero, before you finish, if we agree with your position that this element of damage is totally like it, what are you suggesting it to be your the remedy?
One of two things, Your Honor, and I'll be honest with you, it's probably in your discretion. I just had a case in the 11th Circuit and similar arguments where they said they didn't prove their damages, but we are exercising our discretion and granting a new trial, even though the appellant didn't ask for it. We think that it's a failure of proof. Per my discussion with Judge Kelly earlier, they didn't prove their damages. It was incomplete. They haven't even distinguished or addressed the restatement. They don't even mention the restatement in their brief, even though we mentioned it in our initial brief. So first of all, we believe that it's a remand for entry of judgment in our favor because they didn't prove damages. But to be honest, you may say, we're going to reverse, but we're going to remand for a new trial. So, and we did that in the alternative in our conclusion. That's what we asked for in the alternative. But this is not one of those cases where you remand for a new trial because there was evidence presented that should not have been, or evidence excluded that should have been admitted. This was evidence that they could have put on that.
This would be more like, this is more like a second bite at the apple situation.
Yes, Your Honor, and there are cases to that effect that say, you don't get a second bite at the apple. This was your opportunity. You didn't use it appropriately, and so we're remanding for a judgment in the defendant's favor. And that is obviously our position number one. And I don't want to spend any more time unless the court has other questions.
I think we're all-
Thank you for your time and your courtesies.
I will note that I've never known an apple that could be eaten in one bite. I don't fully understand the expression. You guys met our expectations, for the most part.
Well,
It's
I know
good to
Mr.
see
Brannick
you.
always exceeds expectations. I know him very well.
It's just nice to see some lawyers